The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
You may be seated. We want to welcome everyone to the Fourth Circuit Court of Appeals this morning. We have three interesting cases, and we look forward to the arguments. In the first case, Consumer Financial Protection Bureau versus Nexus Services, Mr. Lawrence.
Yes, Your Honor.
Good to have you with us.
Lovely to be here.
You may proceed.
Thank you. If it may please the court, I'm Zachary Lawrence here for the appellants in this matter. I'm going to keep things fairly brief. We have just a few issues on appeal. There was a default sanction entered by the lower court in this matter. In addition to that, there were Rule 37 sanctions issued after the fact. We also had the issue of calculation of damages and whether or not a revenue-based calculation is appropriate given the Supreme Court's holding in lieu. And last, we're going to be dealing with Rule 65 sanctions and whether or not those were waived and whether or not the conditions of Rule 65 are mandatory for every injunction. So I'll start off with Rule 65 sanctions and the waiver issue because that is likely the most interesting issue.
Rule 65 sanctions.
Excuse me, Rule 65 and the injunction. So in this matter, a default sanction was entered against defendants and an injunction was requested. After the default was entered, the court ordered briefing in preparation for a damages hearing. Within that briefing, the CFPB, along with the state plaintiffs, requested 7 separate injunctive provisions. Those 7 separate injunctive provisions took up approximately a page, and they involved essentially no longer being able to make certain misrepresentations to clients regarding the scopes of Nexus Services services, which were immigration bonds, no longer being able to make certain representation with regard to collections efforts with those bonds, providing contracts in the language of a consumer, not assisting any other corporate defendant in similar violations, no longer using GPS devices, and no longer collecting funds for the GPS devices or retaining them. That rather narrow set of injunctive relief that was requested in the final order and judgment turned into approximately 70 different provisions. That covered everything from reporting requirements to record-keeping methods to forcing all employees or contract vendors to sign an acknowledgement of the order that essentially would have made them vicariously liable for contempt should they attempt to do it. And none of these things appeared in the trial briefing. Nor is there any explanation given the complaint and the trial briefing as to why those rather broad injunctive proscriptions appear in the final order. Again, you went from a complaint that requested that certain harmful behavior be enjoined. You had trial briefing on 7 separate injunctive provisions, and then you had a complaint with well-nigh 70.
Most or not all of the facts were conceded, weren't they?
All of the facts relating to liability were in fact conceded, yes. So initially I believe you had 15 counts. However, those counts had to do with certain representations that were made to clients.
You're saying the injunction is not specific enough?
I'm saying the injunction doesn't specifically relate to the damages complained of, nor to the issues that were immediately relevant.
It fails
To
to
the
qualify
case.
with Rule 65E or something?
So, yeah, I mean, the lack of specificity certainly was an issue under Rule 65D. The lack of reasoning for the particular injunctive provisions issued also was a significant reason. I would claim that it fails to comply with Rule 65D.
Well, show us in the record where you made that argument before the district court that the, under 65D, that it was invalid.
I did not, nor did I know that the injunctive
So
provisions
you-
would be so broad.
Why wasn't all that waived then?
Why wasn't all of that?
Your complaint wasn't specific enough, wasn't presented to the district court.
Naturally, because I was presented with 7 injunctive provisions that I thought were reasonable, given the complaint. So I'm presented in trial briefing, and my clients are presented with the fact that they are now liable for certain violations of consumer protection law. There was no question about that. Default had issued. We admitted that. I then received trial briefing that contains 7 separate injunctive provisions, which I think are reasonable, given that we've admitted to liability. Thus, I don't oppose them, I don't object to them, I am perfectly happy with those 7 provisions. Thereafter, a final judgment and order issues not with 7 provisions, but rather with close to 10 times that.
And what's the problem with those provisions?
The problem with those provisions in part was they don't relate to the harm complained of, in part that they're, quite frankly, flummoxing, right?
How do they not relate to the harm?
For
They all seem to be about not committing these violations anymore and ensuring that, it doesn't, that they make it right and that they don't do it again.
For instance, temporally, these are vastly broader than the harm complained of in the complaint, and that admitted and proven. So you had in the complaint certain practices that were occurring between, I believe, 2014 and 2018 on contractual provisions specific to those 2 agreements. We're one to look at, say, the definition of an effective customer or the effective date that both predates those contracts and postdates the harm shown. So it would go not from 2018 or people subject to those 2018 contracts, but rather any consumer of Nexus Services products between its founding and the date of the order. Again, just because of definitional issues with the injunction. Additionally,
Well, so that's saying the court found or you admitted to violations within a certain span of years, and the court ordered you to, make it right and not commit those violations at any time, right? I mean, what's the disconnect there?
the disconnect is many of these consumers might not have been subject to the deceptive practices that were demonstrated by admission of the facts in the complaint. So again, for instance, if a consumer were to sign an agreement that was used in 2020, simply because the 2018 contract was deceptive or wasn't presented in English, doesn't necessarily mean that that 2020 consumer would have been deceived, either by the contracting processes or anything else.
But what are your obligations under the injunction to that 2020 consumer?
Our obligations to that 2020 consumer are to no longer accept funds from them, essentially the obligations aren't to the consumer, they're to the CFPB and to New York and to third parties.
Right.
The obligations to the consumer are parts of the injunction to which either in the requested relief or the relief as it was ultimately granted, we take no real issue with. We aren't looking to put GPS devices on 2020 consumers, nor are we looking to present them contracts in English, et cetera. The point being, though, say with the transmission of information from clients. Nexus Services was sold. It was sold in a manner that at least at trial, it's been argued violated this particular injunction. I believe it's 19 of the order, paragraph 19, prevents the transmission of customer information essentially all time, up to the effective date, which would be approximately April 2, I believe, of 2024. Say a consumer calls up Nexus's successor and demands for a refund. Nexus's successor has no information about that consumer. Zero. And they can't, because of paragraph 19 of that order, or at least because they're attempting to avoid contempt due to the contents of paragraph 19 of that order. To shift gears here slightly, I'll move on to the calculation of damages.
What are you moving on to?
The calculation of damages?
Calculation of damages.
Correct, under net revenue. So, in essence, our argument is that this court should adopt the Seventh Circuit's analysis under First Legal. What the Seventh Circuit did in First Legal is it looked at the Supreme Court's holding within lieu, and it held that because the trial court was utilizing law that dealt with equitable precedents, equitable ideas, essentially relief at equity, the trial court may have granted equitable relief, and therefore the net revenue calculation could not have been utilized because of the Supreme Court's holding.
And did you make this argument before the district court?
I did make the argument before the district court that the actual loss portion was never shown. So within trial briefing, what I stated was that Gordon and the use of net revenues was inappropriate in this case because consumer loss was never shown.
So you're saying this issue was preserved for appeal?
I believe it was preserved in the trial briefing. I believe, again, I put forth that under this standard, one needs to show that net revenues approximates actual loss. It was a burden.
But the number was the proposed number Nexus that gave to the district court, correct?
So the numbers were the revenues of Nexus. Nexus couldn't lie about its revenues. Nexus made approximately $200 million minus refunds. That's all established. Where the problem came in was that these numbers, the revenues of Nexus, didn't represent actual consumer loss. The idea, at least as I understand behind a net revenue calculation, is one need initially to demonstrate that net revenues approximates actual loss. And in this case, I think, based on the allegations admitted in the complaint, you have a showing that consumers got, in essence, exactly what they paid for. So the complaint goes through.
So you're saying that the numbers are too high?
I'm saying they don't approximate actual loss, and thus both as an equitable remedy and a legal remedy, net revenues would be the wrong calculation. So initially, as an equitable remedy, net revenues requires one to show that the revenue approximates consumer loss, and you don't want to allow someone to unduly benefit from their wrongdoing.
So what was the proof that you offered of the legitimate costs that should be deducted from the net revenue to reach the actual loss to the consumer, to reach that amount?
What I argued was that the complaint stated these consumers were desperate for release from jail and
I'm sorry, what was the evidence you presented of the amount that should be deducted, right, the legitimate costs that were charged?
I did not. I argued rather that based on the allegations in the complaint, benefit to the consumer, indeed the main benefit of the bargain.
You didn't present any evidence?
I was not able to, no.
So I thought it I'm sorry, Judge.
No, you go ahead.
I thought there's a two-step inquiry. The government presents its number, and then you come to, they have to, give some evidence of the amount of loss, and then you come forward with your evidence to deduct from that what was an appropriate and legitimate charge to reach the final number. But you say there's no evidence at step 2.
So no, rather I say they don't meet the burden at step 1. I believe the government's burden to utilize this net revenue calculation is to show that net revenues approximate.
Well, the first step is just the government bears the burden to show the amount it seeks in restitution.
Again, I could be wrong, but I believe case law speaks to that number needing to reasonably approximate actual loss.
What's your best site?
I believe you would have that in
that
Gordon.
the government bears the burden, that it's not your burden to show that this was not actual loss.
I believe in describing the test, Gordon states that. I believe it's also in Febre, F-E-B-R-E, and that's
that must be a measure of loss to the individual, not gain by the defendant.
It's loss. I believe it's reasonably approximates loss.
And you say that that wasn't demonstrated in the evidence. How?
Again, because essentially consumers got the main benefit of their burden
How do we know that? What's the evidence of that?
because of the complaint and that it wasn't in contest. So within the complaint, it pleads that there are desperate consumers seeking freedom that have no other option. I cannot give you a paragraph site. I believe it's going to be in the introductory paragraphs.
So it's just the argument that they were desperate for help.
They were desperate for help, and they
So
in
we should
fact.
assume that they got something.
Well, no, it states that they received the very help they were seeking. So it states that they are released from prison. They're issued a bond. They are then taken to, I believe, a McDonald's. They are then taken to a hotel. They are then free for the pendency of their case within immigration court. In essence, they wished to leave jail. They paid, and they were able to leave jail. So they got the main benefit
So that
of
was
their
the
bargain.
argument. Okay.
Thank you.
Thank you. You've saved some time. Mr. Turner? Ms. Turner, I'm sorry.
May it please the court, Larkin Turner for Plaintiff Appellee Consumer Financial Protection Bureau, and with their consent, arguing on behalf of the state appellees. So for 2 years, appellants refused to meaningfully participate in this case. I will jump to the injunction and restitution issues. This court should reject appellants' forfeited complaints to the terms and scope of the district court's injunction. Appellants waived any objections they might have had. They repeatedly failed to press them in the district court. They only vaguely have raised them in this court. But even if you set aside the waiver, the claims fail on the merits. The order complies with Rule 65D, and the district court did not abuse its discretion in imposing the scope of relief here, which is reasonably related to defendant's serious misconduct. Appellant's challenge to the district court's award of monetary relief fails for 3 independent reasons. First, as the district court held, and as we argued in our brief, the award is independently justified under the Consumer Financial Protection Act as a refund of monies. So this court can affirm on that basis. It was an independent basis and an alternative basis the district court explicitly held in her order on which this can be affirmed. Second, the district court ordered legal restitution. Lieu v. SEC is about equitable remedies. This is a legal award of monetary relief. We were not tracing funds, seeking particular property. This is not an equitable award. Appellant's attempt to transform the legal restitution that the district court awarded here into equitable restitution is inconsistent with the district court's order. It's inconsistent with Supreme Court precedent distinguishing between equitable and legal remedies, and with this court's precedent doing the same. And finally, for the reasons, Judge Rushing, that you were just discussing with my friend on the other side, even if lieu were to apply, the district court's order complies with lieu. It represents a reasonable approximation of appellant's unjust gains based on the evidence it had before it, which was appellant's stipulated figure of monies it collected from consumers less the refunds already provided. There was no evidence on which the district court could have otherwise subtracted any amount of money from that award. If there are no questions, we respectfully ask that this court affirm the district court's judgment. Thank you.
Thank you very much. Mr. Lawrence?
Yes, Your Honor, I'll be exceedingly brief. So, extremely quickly, I don't believe the court describing their relief as being legal is of any moment. Again, I would urge the court to adopt the Seventh Circuit's analysis in First Legal. I believe that's amongst the only precedent dealing post-Leo with a restitution award of this sort. The trial court here did exactly what the trial court, or district court, did in the First Legal case, which is rely on equitable precedent to issue an equitable award. The only additional thing I would say is that one is going to look toward the nature of the award rather than any language describing it to determine whether it's legal or equitable. The award here is payable on 10 days. It's supported entirely on a jurisprudential basis of equitable remedies. I do believe it to be equitable. Lastly, I would just note that there was virtually nothing that could have been presented in opposition to the final injunction. Appellants simply were unaware it was going to take the scope, the breadth, the form it took. Prior to...
So you couldn't have objected, is what you're saying?
There was no method because the appellants had no idea this was going to come. Again,
No
appellants...
idea. Well, you can even make post-ruling objections and motions. They're provided for in the rules.
We had noticed appeal by that point.
You could have shown up at the hearings. You could have litigated.
With all due respect, do not believe I could have because I wasn't counsel at that point. Post my entrance into the case.
You is
the royal you.
client.
Sure. Again, I think you're talking about a default judgment very, very quickly followed on the heels of trial briefing wherein an injunction was proposed that appeared acceptable.
There was no
reason.
motion to reconsider.
There wasn't because appeal was noticed, and the assumption was that appeal would provide the remedy we saw, which was overturning the injunction for overbreadth.
You filed a timely notice of appeal.
Most certainly we did.
You knew when,
And
you knew what the rules provided on that.
we certainly did.
But you didn't show up for court for a long time.
Again, I believe the clients were having rather significant hardships that are spoken to both in the appellate briefs and the record. That being said, there's a vast difference between not showing up to court or not providing income statements and what was in essence a penalty of $800 million, which is really what this case comes down to. Appellants could not contest liability nor damages, and these sanctions were extremely severe. But given the very brief argument of the states and the CFPB, that is all appellants have, unless anyone would like anything further. Thank you very much.
Thank you, sir. We will take the matter under advisement. We'll come down and greet counsel and then go to our next case. You may be seated. Next, we have two consolidated cases. Hoffman versus Inova Healthcare Services. Appellants are represented by Mr. Bosson.
Yes, Your Honor.
Good to have you with us, Mr. Bosson.
Good to be here. May it please the court. My name is Tim Boston. I represent the appellants, Kelly Hoffman and Lorraine Biondi Austin. We appeal two errors of the lower court. First, that appellee Inova was not found to be a joint employer of the appellants. And second, that Mrs. Hoffman's attempted amendment of her EEOC charge to add appellee Napa as a party was found deficient. A joint employment determination is controlled by the 9-factor test established by this court in the Butler v. Drive Auto case, where the court made clear that the test is to be fact-intensive, and one for which a district court is generally not, quote, equipped to rule even on the basis of a summary judgment record alone, making remarkable that the trial judge here decided these cases on a motion to dismiss. As established in Butler, the first three factors are the most important, and I'd like to start with the first one, the authority to hire and fire the individual. On this point, the lower court found that, quote, appellants have not alleged that Inova had the authority to hire and fire. That was surprising because our amended complaint, and I will cite to Ms. Hoffman's amended complaint there because the facts are the same in both. This is at Joint Appendix 205 of Ms. Hoffman. But Hoffman, her amended complaint at paragraph 24 states, Inova retained the right to terminate appellant's employment at Inova, directly contradicting what the court found. But more importantly, Inova did in fact terminate the appellant's employment with Inova.
Well, is that the authority to hire and fire? I mean, saying Inova had the right to prevent her from working at Inova isn't necessarily saying they have the authority to fire her from her job, right? Because you also alleged that she's hired by what is now Napa, and that's her, you know, who her contract is with.
Yeah, I don't think our briefs are as clear as they should have been on this point, Your Honor, but our position really is that they terminated her job at Inova. Counsel, or my esteemed opposing counsel, has argued in their brief, I think 11 times, that this was about suspending privileges at the hospital or just removing her from the hospital in that way. That is not what we are arguing.
How do you explain the 2-month, as to Austin, the 2-month delay between the suspension of privileges at the hospital and the actual termination?
Yeah, again, I think we confuse this issue by crediting the argument. The real issue here, and this is the third element in any Title VII discrimination claim, is was there an adverse employment action? And so what we are arguing is the adverse employment action is when my client was terminated from her job at Inova by Inova.
No, but my question is, you would agree that there was a 2-month
Yes.
delay between the suspension of privileges at Inova and the actual date that I guess you would use for termination?
Well, yeah, again, I'm trying to step back. That is how the pleadings have made it sound, but that is not our argument.
But is that what happened?
No.
So there was not a 2-month delay between the suspension of privileges and actual termination as to Austin?
Yeah. As to both people, there was a time when Inova removed them as an employee. And let me back up. This was not highlighted in our brief, and I apologize. I think we've confused the fact, and it's our fault. But if you look, this is Austin Joint Appendix 216. The emails that Inova sent to my clients, the appellants, when they denied their COVID vaccine exemption request, said, and I'm quoting, the failure to comply with the vaccine requirements will result in an unpaid administrative leave, and further failure to obtain the COVID-19 vaccinations would mean your employment with Inova will end. Team members terminated for failing to adhere to company policies, and it continues. Inova, and we noted this is footnote 2 in the Hoffman amended complaint. They used the identical paperwork, I'm quoting now our footnote, the identical paperwork that Inova provided to all other employees.
Okay, so back to my question. The ban was August 1st, right?
Termination. I mean,
So when the privileges were suspended, okay, so you're
that's not in
saying,
the record. That's
so
the
you're
problem.
saying August 1st was when they were terminated?
Exactly. From their
But they continue to work for Napa until September 29th?
There was
Right.
no work. The reality was they
Well,
were sitting on some kind of administrative.
they would continue to be on Napa's, I guess, payroll or whatever until September 29th.
That's correct.
Okay, that's the only thing I'm asking. But
Yeah.
your position is, and I understand that, but I just want to get those dates straight. But your position is that they were terminated from Inova on August the 1st.
Yes. And I think this is where we made a mistake in our briefing, not to clarify this point. It's an adverse employment action. And so, meaning, and I wanted to explain this. Inova removing my clients from their employment, Inova's words, at Inova, and on August 1st, was an adverse employment action. Whether you call that a suspension, whether you call it whatever.
Well, that's a nice way to try to dance around the pivotal issue, which is it an employer, right? That's what the district court talked about, and that's what I thought we were talking about here, is that you can have an adverse action, but it has to be by an employer.
That's right.
What does the complaint allege about who was the day-to-day supervisor of these employees?
Yeah.
Who
And that is correct.
supervised their day-to-day work? What does the complaint allege? I didn't see anything.
Okay. Well, on that point, this is factor 2. I'm looking at Hoffman Joint Appendix 203, paragraph 18. We said, Inova set and monitored Mrs. Hoffman's work schedule and could approve or disapprove her time off.
Right, so the complaint alleges that Inova could deny medicines for patients, and that Inova, there was one instance that applied to both women where something happened during the day and Inova staff member said, you can go home. Turns out that was wrong. They weren't allowed to go home, and Inova disciplined that. But that doesn't say anything about day-to-day in their job as anesthesiology nurses, right?
Right.
Who's supervising that day-to-day? Does the
Well-
complaint say?
Yeah, but I do want to emphasize, the Silicek case.
Sorry, does the complaint say? Does it
was-
allege who's supervising them
Well-
day-to-day in their work?
Other than the medication, I don't think, I think that's the only allegation, but I wanted to point out.
And these were amended complaints, right? The district court had already pointed out the deficiencies and said, give it your very best shot to allege everything you can to show me why they were Inova employees under Inova's control. Right?
They were amended complaints, and yes, we did give it our best shot, Your Honor. But I would point out, we didn't have discovery. The contracts that were attached to the motions to dismiss were not in our possession. And then as we noted, they were heavily redacted. So we don't even know what other, provisions were in there. I would note, though, in the employment contract with Ms. Hoffman, which was the only contract that was attached, Ms. Austin's was not attached to the motions to dismiss. But in Ms. Hoffman's, it notes that she was supposed to be under the supervision of physicians. And I would point out, she was under the supervision of all physicians, not just anesthesiologists.
I
at
know that
Inova.
this is on a motion to dismiss, and so there might be some debate about whether the contracts are integral to the complaint, but is there any, I know dispute is not the word because we're not at summary judgment, but is there any disagreement that the entire anesthesiology department were NAPA employees, that no anesthesiologist could work at Inova except for NAPA employees?
That we, We objected to the authenticity of that document that did say American Anesthesiology was the exclusive provider of those services. We don't know, and I think my clients would say that they did bring in traveling nurses to assist. So no, I don't think they were, in fact, but we never got to that issue. Again, we didn't have those contracts. I mean, my client had never seen the contract between American Anesthesiology and Inova until they were attached to the motion to dismiss. We were very handicapped, obviously, to argue against those. But I do think that's what that purported to say, is that they were the exclusive provider of the anesthesiology services at the hospital. But again, I want to point out too, right? My clients are nurses. They take instructions from doctors. That's all doctors. That's the doctors at Inova. So it's more than just the anesthesiology doctors. And obviously, as this would come up, one of my clients, Miss Austin, worked in the surgery center. So she would have worked with surgeons. And I'm sure they would have
Didn't she list
instructed.
on her vaccine exemption form that her supervisor was an anesthesiologist?
That is a fact question that should be, looked into in discovery, Your Honor. But she did do that. But I would say, I think that's the intermediary, not the day-to-day supervisor, but the person who ultimately had, the back and forth, the liaison, if you will, between American Anesthesiology and Inova. Again, that counters our pleadings. We said that it was Inova who had the right to monitor I realize I only got 5 minutes, to monitor and ultimately decide how to treat our clients at Inova.
You allege that Inova set and monitored the schedule. Like we can't read more into your allegations than is there.
Right. We went past that. We talked about it was Inova who would address any problems directly with our clients. I think this is paragraph 18 of our amended complaint. There were other allegations in there as to this issue. But I'm trying to point out, the Silicek case made clear that it's not so important who controls the professional work, if you will, in the medical context. It is more important who schedules the employee. It literally says there about a doctor, who decided which hours the doctor would work.
Silicek might be a little different because that was the doctor, right? There's not really a supervisor for
Right.
the lead doctor.
But I think that makes our case simpler, or it's easier for a nurse to be found to be under an employer, whereas a doctor, and Silicek was dealing with an independent contractor context as well. So,
Are you aware of any other court that's found that has found a joint employment relationship between a hospital and a staffing agency?
the Sibley Memorial Hospital case out of DC, the DC Circuit Court, which was cited by Butler, was one such case. There was also the Crump v. T.C. Coombs case that we cited to the lower court, which was another Eastern District of Virginia case. That was a physician assistant. I've looked throughout the nation, and there aren't cases on either side of this issue. So I think, to the court's point, I jokingly wondered if nurses just aren't litigious, because there's a lot of doctor cases, but there aren't many nurse cases. To the extent that there are, the Crump case in the Eastern District was found in our favor. And so I would point the court to that case. And it would make sense, actually, that nurses would be treated differently, because there's more control that's going to be placed on a nurse by a hospital than there would be by a doctor who's going to work without supervision generally. I think we've covered the first three factors. The other factor that was considered by Butler, and I think the Butler court found important, was the seventh factor, which is whether the individual's duties are akin to a regular employee's duties. The Butler court there clarified that what they were concerned about is whether the work was, quote, tangential or peripheral, or if it's the same task producing the goods, the same goods that are core to the business. Here, my clients, I know they were doing anesthesiology, but they were nurses. They were producing the same product for Inova. They weren't janitors or outside contractors, maintenance people. They were healthcare providers, just like everybody else at Inova. So that factor weighs in favor of our clients as well. I would just note quickly that
Could Inova substitute? You're saying, so are the nurses fungible? Could a nurse without these special qualifications substitute for your clients?
I don't think they're fungible. Just like I don't think the employer in the Butler case, working in a manufacturing plant, I mean, employees might be doing different parts of the process. But ultimately, the core good, if you will, to quote Butler, is healthcare services. So this is exactly what Inova does as its core mission, was exactly what my clients were.
I guess I read the seventh factor, when they're akin to a regular employee's duties, to be asking maybe a more specific question than that. And whether, you know, whether they can be interchanged with regular employees. And here that, you know, when the entire specialty is not interchangeable, that seems like a hurdle for you.
Well, on the surface it would, but again, quoting the Butler language, what the court said is we're really focused on are you working in their core processes, what this company exists to do. And in that case, I don't think it's a hurdle. I think we're very much doing what Inova exists to do, which is provide those services. And I would note also, I mean, our nurses, this is paragraph 23 of our amended complaint, also did things like placing IV lines into patients, repositioning patients, things that any other nurse would do as well. So, you know, they weren't exclusively doing anesthesiology services. And to the court's question, I would also note paragraph 19, we also noted they wear the same uniform down to the shoes, same badges, and they're indistinguishable from other nurses in the hospital. I would just say really quickly, Butler was concerned about effective control, not formal control, and we think Inova exercised that effective control in this case. And I'll reserve the rest of my time.
Thank you, sir. Mr. Logan?
I feel I need to be taller. Good morning. My name's Nancy DeLogue. I'm here for Inova Health Services. I want to emphasize a couple of things right off the bat. These two cases do not present any novel issues of law. The issues presented are simply whether either of the two appellants included in their amended complaints facts sufficient to state a plausible claim that Inova was their joint employer, and they did not. And I want to clear up something that came up in, Mr. Boston's argument just now. These individuals are not just nurses. These nurses are anesthesiology nurses. The first paragraph as to part use, as to each individual, Joint Appendix 201 for Ms. Hoffman. Ms. Hoffman is a certified registered nurse anesthetist. This is important because Inova employed staff nurses are outside the record, but they are not medical staff members. These two individuals were medical staff members by virtue of their specialty practices, and I just want to clear that up. Mr. Boston may have confused the issue, but they are here to provide anesthesia, and I don't know what to say about it beyond that, because that really is outside the record, that to suggest that they are nurses alongside with everyone else at Inova. Whether someone is a joint employer, of course, is an issue of law for the court to decide, and that legal decision can appropriately be made at the motion to dismiss case. This court has held in 2021, Smith versus CSRA. It was the case that said that it's an issue of law, and it's the Lemon v. Myers Beagle case from also earlier in 2021. Also the Bender versus Suburban Hospital case, a little bit older, 1998, disposed of the joint employment issues on a motion to dismiss. Clearly, plaintiffs were aware of the joint employer standard. They actually pled it in their initial complaints. And despite being full notice and an opportunity to be heard regarding why the complaints fell short, each then filed an amended complaint that again failed to include more than conclusory allegations about their relationship to Inova. Now, significantly, this court has held that the Rule 8 pleading standard does not require a court to accept as true unwarranted inferences, unreasonable conclusions, or arguments. And that is significant because each appellant acknowledged in her pleading that she was assigned to perform services for Inova pursuant to a contract between Inova and what is now NAPA, the anesthesiology practice. That's at Joint Appendix 9 for Ms. Hoffman, paragraph 12, and Joint Appendix 7, paragraphs 10 and 11 for Ms. Austin.
And when ANOVA provided the relevant portions of that agreement as integral to the allegations made in those amended complaints, the court correctly recognized that these documents could be considered on a motion to dismiss. And as we know, where the allegations of a complaint contradict any attached exhibit, the exhibit prevails. We did see some contradictions there. Ms. Hoffman's employment contract with NAPA contradicted her allegation that she would be terminated for cause if ANOVA demanded that she be removed from providing services. In fact, when the court looked at it, it says that agreement says, if ANOVA removes you or suspends your medical, it didn't say ANOVA, but if the client suspends your medical privileges, then NAPA may, after due consideration, decide to remove you from its employment as well. So that was strictly between them. Whether they exercise that right and whether they did so later is entirely separate from whether ANOVA retained that right, which is the standard we're looking at here. So we've gone over the 9 Butler factors, and I will come back to the first element, the right to hire and fire the plaintiff. Just to be clear, because I don't think it's really addressed in the record, there are no allegations that ANOVA played any role in hiring either of these individuals. They weren't interviewed, they didn't fill out employment applications. There's no allegation that, they, asked them to not work anywhere else. And I think that distinguishes this case from the Chavez-Deramer decision that this court issued just this July. That was an FLSA case, but it also involved nurses. So I wanted to bring it up. No allegation that ANOVA played or had any right to engage in any hiring decisions. With respect to terminations, I do think my opposing colleague here has confused what would be an adverse employment action under the Muldrow standard with the right to hire and fire, which is a different factor used in Butler to sort of to focus on the common law element of control, who controlled. And so I want to be clear that I understand they are alleging that had ANOVA been their employer, being suspended from medical staff privileges could have been an adverse action, but since ANOVA did not have that control to be their employer, that falls short here of saying something else. Ms. Hoffman also alleged in her complaint that, following her suspension from employment with NAPA was a dead letter. I think the court has raised some good questions about that. There's been no repudiation of the fact that she was not, in fact, actually separated for another few months. And in fact, at Hoffman's record, Joint Appendix 111, NAPA actually controverted that argument by saying that it had offered her alternative assignments both before and after ANOVA had suspended her medical privileges.
Can we consider that? That's not in the complaint, and it's not even in any of these contracts that were may be integral to the complaint.
I think it's interesting, right? It's in the joint appendix, and it is because of the separate arguments which haven't been raised that NAPA should be in the complaint and that they actually took adverse employment action. I don't know
like at
whether
the
it's properly here for
12B6
ANOVA.
stage, we're looking de novo at the same standard the district court had to apply, and I mean that has pretty strict blinders to just look at the complaint and its attachments, right?
I think that's correct, however.
Maybe we need some discovery here.
I don't think discovery would be helpful in this matter. So just to answer Judge Rushing's question, NAPA attached those as integral to and responsive to their allegations, the allegations against NAPA, and I don't believe they were controverted.
But that's
and so,
not the
again,
standard, right? It's not what the defendant thinks is integral to how they might defend against the complaint.
Absolutely, that was a motion to dismiss on their part, however,
Yeah.
and is integral to the report. Maybe more importantly, that has not been refuted. And I don't know why they
I'm
wouldn't.
sorry, I don't want to get you hung up on this, but
Yes.
they don't have to refute your allegations at the 12B6 stage, right? The
They certainly
plaintiffs
do
get
not.
to make the
They certainly
allegations,
do
and
not,
we
but
are supposed to credit them.
Understood. If it were my complaint, I might have addressed it, but that was not here. I don't think that so with respect to the hiring and firing, though, I think the allegations were contradicted by the complaint, by Ms. Hoffman's employment contract with NAPA and to a lesser extent, the contract that Inova supplied that it had with the anesthesia practice that would have applied to, that did apply to Ms. Austin. Now, Mr. Lawson has alleged that they objected to that, the production of that document as well in response to their motion, and I think that's a little inaccurate. They objected to the fact that portions of it were redacted. They did not question its authenticity, and I think that that, again, a district court is allowed to consider that in those circumstances. And again, they had an opportunity to address that and to be heard not once but twice by the district court. The day-to-day supervision of activities, the second factor, I think was also covered pretty well. I don't believe that there are substantial allegations that anyone at Inova supervised their work. I will say that she wasn't, the allegations that Inova checked her licensure, imposed badging requirements, even decided which medications to make available, all go to the sorts of standards that a hospital has to meet for professionalism standards. They don't go to controlling her work. There's no allegation, for example, that if Ms. Hoffman determined that a individual needed a particular medication, that Inova would say, no, they don't get any medication. The allegation was simply that certain medications might not be available. And I think that's significant. She is still left with the authority to make decisions about what her practice believed was appropriate for the patient. With respect to the disciplinary situation, it is quite vague. I think it's too vague, frankly, to put Inova on notice of the allegations against it in that regard. However, the last paragraph, and my colleague discussed this, in the amended the complaint that suggests that something uncomfortable happened at work and that she, one or both of them were sent home, after which a suspension followed. The only suspension that has actually been alleged to have occurred in this circumstance is the suspension of the medical privileges. And I don't know whether that was something upsetting that happened or not, but it's too vague to actually be a meaningful, and to put us on notice of what Inova is alleged to have done there. I don't know how it can be meaningful to this court in helping decide whether Inova had day-to-day supervision of her activities. The place of work I want to touch on briefly. I think it's interesting, right? Of course they were working at the hospital. Hospitals are where anesthesia patients are. But the third factor about whether Inova supplied the place of work is not as strong as it would be in this circumstance. And the two cases that sort of support that from this court are, of course, the Tsilecek case and the suburban hospital case, which kind of collected all of these examples that explain why medical professionals may be treated differently, and why the provision of a hospital staff and making sure that the hospital is run in a way that meets federal regulatory requirements does not weigh, right, in terms of hospital controlling the actual practice. I think the last point that, to just address my colleagues' arguments, in Tsilecek is helpful for discussing indicia of control. I think that there is a very clear claim that had Inova controlled these individuals as it did their nurses, we might be in a different circumstance. And so I do want to come back to the fact that that's not accurate. But the appellants here didn't challenge the authenticity of the contract between Inova and the other one. There is a different standard that applies here, and I think it's the Lemon case that states to find employment here would be really stretching the bounds of what constitutes employment too far. And if so, it will be past the breaking point and upend understandings that have been central to the organization, not of that law firm in this case, but of hospitals' care for decades. And again, the Tsilecek case has stood with this court since 1997 and the Bender case since 1998. If the court were to rule otherwise, it would be making a big change in how hospitals organize their practices. Thank you.
Thank you very much. And Mr. Signer?
Good morning, Your Honor.
Good to have you with us, sir.
Great to be here. May it please the court. Scott Signer on behalf of North American Partners in Anesthesia. In this case, the issue for my client is fairly clear-cut, and I'll try not to complicate it too much. And I believe my opposing counsel actually summed up what the critical issue is. And he framed it as an attempted amendment of a charge of discrimination. And that's really the issue. This was an attempted amendment. It wasn't an effective amendment.
So what did, I couldn't understand from your brief, what did Ms. Hoffman not do that she was supposed to do? What was she supposed to do to exhaust that she failed to do?
Your Honor, I think there's a kind of a compounding nature of what was not done. In this particular case, and I'd go back very quickly to this court's precedent on the issue.
I'm sorry, this is like a straightforward factual question. I just want to try to understand, in the EEOC's process, there is something that has to be done to amend, and you're saying she didn't do it, and therefore she didn't exhaust. So, like, what is it that she's supposed to do that she didn't do?
Yes, Your Honor, it would be to ensure that a formal charge, or at least a notice of some sort, to provide a charge to the EEOC that ensures that notice was provided to the respondent.
I didn't think that complainants provide charges to the EEOC. Thought the EEOC gives the charge to the complainant.
Yes, Your Honor. to
Okay, so
ensure
walk
that a
me
formal charge
through
was
what
filed.
didn't happen, like step by step, because
Your
this
Honor,
is confusing.
Of course, Your Honor. In this particular case, there was an initial charge filed. There's no dispute that that initial charge identified only INOVA. The allegations only spoke to INOVA. There was a subsequent personal letter that was unsigned that was submitted by Ms. Hoffman with her attorney copied. So she had counsel throughout this. That letter requested or advised the EEOC of intention to amend. And thereafter, and that was submitted, I believe, approximately 9 months after the initial charge of discrimination. Now, that letter was not followed up with by counsel. They received a notice of right to sue that identified INOVA. In fact, in the joint appendix at page 7.
So that's what happened. So what is supposed to happen? If someone wants to amend their EEOC charge, what does the EEOC tell them to do? What are they supposed to do that she didn't?
In this case, Your Honor, given that Ms. Hoffman was represented by counsel, I would take the position, and I believe the case law addressing this is distinguishable because most of it involves pro se plaintiffs or individuals at least acting pro se. But I think at the least there's an obligation to exercise some due diligence in the sense that they would need to follow up, in particular, given that she received a notice of right to sue that identified only one respondent versus 2 respondents as she wanted or attempted to amend the
I had to
charge
go
with.
try to find what the EEOC requirements are on my own because it didn't tell me. But it looks to me like, according to the EEOC, you're supposed to send them something saying, I want to amend, right? So that they've already given you their summary of your charge, and then the complainant says, I want to amend, right? So here she has her letter, she puts her claim number on it, she tries to tie it to her existing complaint and says, I want to amend. It's titled, something like amendment, right? But the EEOC then has to respond by actually evaluating it and amending your charge. And then they send the complainant an amended charge that the complainant can then choose to accept or reject. And then it is amended. And it looks like we have no information about, she says she tried to amend and that didn't happen. So why is that her fault? What was she supposed to do that she didn't do?
Your Honor, again, I think the distinction here is that the cases that speak to this issue, and I understand they're factually distinguishable based on the fact that I believe all or most of them included communications by individuals who are unrepresented. The distinction is the notice issue. There must be some due diligence exercised on behalf of Ms. Hoffman here and her counsel, given that she's represented, to ensure, given the passage of time, and I believe this is a fact-specific inquiry.
She tries to amend, she waits and waits, the EEOC doesn't respond with maybe what she expects, or maybe they do, I have no idea, it's not been alleged whether they sent her an amended charge or not. But they send her a right to sue letter, and you're right, it only mentions ANOVA, but at that point, is it, I mean, it's probably, is it too late for her to try to go back and amend? At that point, she has a right to sue letter. I'm still trying to understand what you say she was supposed to do that she didn't do.
Your Honor, again,
Is it like
my
follow
answer-
up? She didn't like
Exactly.
call a few weeks later?
I
And so
think
that's unexhausted for all time.
yes, Your Honor, I would say it's a fact.
Why is that not the EEOC's problem? I mean, they didn't do what they were supposed to do, maybe. We just don't know yet.
Your Honor, I think there's a decision to be made on allocation of fault. In particular here, I think that the analysis is a little different given that she's represented. She's not pro se. I mean, I think the facts in the Cowgill case, which is, I think, the most recent case from the Fourth Circuit that speaks to this particular issue, and I think it's very helpful in the expression of policy that it mandates. And in that case, the plaintiff initially submitted a letter, personal letter, and then his attorney, who he had, you assume had retained at some point, followed up. And it was through that follow-up that actually led to a formal charge of discrimination being filed. And that was the court's analysis. Those were the facts that it was evaluating in Cowgill. And I think that opinion and the ruling there and the holding there, it mandates that we take a closer look at the facts. And in this particular case, those facts speak strongly to recognizing this as an attempted but not an effective amendment. We have an initial charge of discrimination that's filed. There's no dispute that it identifies INOVA only. There's a very belated, in my opinion, personal letter.
Can you amend a charge to add a new target of the charge, like a new employer you're complaining about? I didn't see y'all disputing that, but it struck me as maybe you have to just file a whole new charge.
Your Honor,
Do you know?
I think it's a question I've asked myself. I have not found clarity through the EEOC's website, and maybe that's an issue there as well. But I would think at the least, given, and I think that's another distinction, Your Honor, that is not captured in the argument of opposing counsel, in that a lot of those situations dealt with either substantive allegations or they dealt with new facts. This is a case we're talking about an entirely new respondent. And I believe the responsibility of the charging party, particularly when they're represented by counsel, was heightened. And in this case, she did not meet that requirement. And for that reason, I ask that you affirm the district court's ruling and find that she did not exhaust her administrative remedies. Thank you.
Thank you. Mr. Bosson?
Thank you, Your Honor. Addressing first the issues with NAPA, just as a factual matter, Ms. Hoffman was not represented by us in the EEOC process. She noted that she had consulted with counsel and we were helping her with her. We wrote a letter to ANOVA for her, but we did not assist her. You can see this at JA 154, 155. That updated amendment letter she sent was clearly from her, was not from us. We would not have done the process this way. But to the court's questions, the Edelman case, this is Edelman 2 in 2002, made clear that, quote, the failure by the EEOC to fulfill its statutory duties regarding the charge does not preclude a plaintiff's Title VII claim. And that's what happened here. She did what she was supposed to do. She uploaded an amendment to the EEOC portal, and they apparently took no action. Again, that would be a fact question that would have to go into discovery if we wanted to look into those details. But as it stands now, I believe she did everything that she needed to do. And it's unfortunate that NAPA didn't get noticed, but that's on the EEOC. That should not be taken against the appellant here. If I may, I wanted to turn back. I think I neglected a few paragraphs of our complaint when asked questions earlier about what we pled regarding ANOVA's supervision or actions. And so I just want to point to amended complaint paragraph 15, where we said ANOVA exercised oversight over Ms. Hoffman's work. And we went on to say, making sure to monitor her work. ANOVA staff addressed her directly regarding any problems. And then in paragraph 24, we said ANOVA exercised authority over assigning and supervising the work Ms. Hoffman performed. So I just wanted to clear the record there that there were other allegations in our complaint as to the actual work that Mrs. Hoffman was doing, or both appellants. I neglected to speak to the third factor earlier, and opposing counsel for Nova brought that up. And I wanted to point out, I thought the Crump court, the trial court in the EDVA that addressed a similar issue, there was a physician assistant there, made a very interesting point in saying that it's actually very important who decides the equipment and the location when you're talking about joint employment as opposed to an independent contractor situation like Silichek. The court noted there in Crump that in a joint employer case, it's very relevant which of the two possible employers provides the location and the equipment, because that speaks to the control inherent in such provision. So the third factor, I should have said this, but the third factor is probably our strongest factor. ANOVA, and there's no dispute, they provided the location of the work, and they provided all equipment down to even, this is from the contract that we objected to, but if we're going to use it, down to even the fully stocked anesthesia cart with medicine and supplies. And they continued there to say.
Silichek kind of, I mean, I know that was an independent contractor, but I thought the opinion there kind of cast this third factor as less relevant in the healthcare industry because of where a patient has to be treated and the responsibility that the hospital has for making sure that the proper equipment and all that is used.
I don't think Silichek actually said that. I think Judge Nachmanoff said that in his opinion about Silichek. What Silichek said is the professional standards and the degree of care is less important. And I think Judge Nachmanoff picked up on the concept that, as the court's saying, you know, you have to go to a hospital for some things. But as the Crump court pointed out in another hospital case, you could have outpatient clinics. ANOVA could send people for certain things for anesthesiology to an outpatient clinic run by NAPA or run by whoever else, other employer. So as the Crump court pointed out, and I think it's important, who provided those elements? And to the court's point, even if you take the location, what about the equipment? NAPA could have provided the equipment. So whoever, it is important to see who exercised the control in deciding what equipment to provide to the employee. So in a joint employment case, as opposed to independent contractor, I think it is very important who provided the equipment. So it should not have been dismissed as light. I think it's a very important factor in our favor. I believe, oh, I did want to say just finally, counsel said the Bender and the Silichek cases are basically the Fourth Circuit precedent, but those cases both dealt with doctors, they both dealt with independent contractors. There is no Fourth Circuit precedent on an employee situation like Butler in the medical context. And so we're not asking for any earth-shattering overturning of decisions here. All we're saying is apply Butler to the medical context, particularly to nurses. We understand that we're narrowing our case to nurses, and I think the court should find that hospitals are the effective employers in cases like this. Thank you.
Thank you very much, sir. We'll take this case under advisement, and for right now, we'll come down and greet counsel and then take a short break.
The Honorable Court will take a brief recess. The Honorable, the Judges of the United States Court of Appeal for the Fourth Circuit.
You may be seated.
I think he was here to go in. He must have been in the bathroom.
In our third case today, United States versus Lefferman. Mr. Brown? Mr. Brown, good to have you with us.
Thank you, Judge. Yes, sir. Good to be back here. May it please the court. This case involves right to a jury trial and the constitutional dynamics of it. A legislative scheme cannot determine a constitutional limit. However, in this case, you'll see a legislative scheme can say what the legislature believes is serious is a reflection of what society believes is serious. It also can set an objective standard and one that will promote consistency. And if you look at the interplay and the development of the law regarding Sixth Amendment right to a jury trial and what's come known as a petty offense exception, if you look at that development, 1780s, when it's espoused in the late 1800s, through the due process revolution of the 1960s, early 1970, and then into the information age of the 1990s, you can see that both of these branches worked cognizant of each other and respecting each other.
Before we get to the Constitution,
Yes, ma'am.
you had two arguments in your brief. One was
I
that
did.
constitutionally, even if the max was 6 months.
Yes, sir. Yes, ma'am.
That's all right. There should be a right to a jury. But you had a preliminary argument that, in fact, Mr. Lefferman was subject to a year's imprisonment,
Yes, ma'am.
which I think would mean that's not a constitutional, that's just a question of what was he actually subject to under the indictment and the statute, right?
That's correct.
And the indictment charged him with obstruction by intentionally intimidating and interfering, or attempting to intimidate and interfere, right?
Yes, ma'am.
And the statute defines intimidate. It's defined in this particular statute as placing a person in reasonable apprehension of bodily harm. How does that not involve violence or a threat of violence?
I don't know. And I'll be honest, some of the other circuit cases that address this, that's not the way it was couched there. They used interfere and not intimidate. And in this case, if you look at the record, when Judge Anderson issues his judgment or his verdict in this, he just recites the indictment language. And the word intimidate is actually in his description of what he found that Mr. Lefferman had done here.
Because we have cases about, in a different context, but when we have to analyze crimes of violence all the
Yes,
time.
ma'am.
And we have cases like McNeil, where, we look at length at intimidation, and we always find it to involve a threat of violence.
Yes.
And in here, it's defined to put a person in reasonable apprehension of bodily harm. And I'm curious how that can be a nonviolent offense.
I don't think it can. And Judge, there is some question about the way the statute is written, where there's an exception that then creates a lesser. And I say that because that probably, it looks more confusing now after Apprendi than it did back before, when I would assume this would be considered a sentencing factor back then. But interestingly, if that was merely a sentencing factor in mitigation, you would still get the 1-year penalty under the indictment. And if a court found that it was purely non-violent obstruction, that then in turn, it would have still been a jury trial. So Judge, I would agree that this is a constitutional avoidance way of addressing the situation we have in this case. I do believe that the indictment was not amended. With all respect, I believe it was intended to be.
Well, they took out, I mean, you know, on the record, the court accepted them taking off the one after the B, right? So
That's correct.
that's an amendment.
Well,
didn't-
they said, please file the amended indictment soon. After that statement was made, we will
But did they
allow
ever
you-
take out the allegation of intimidation?
No, ma'am.
Right.
And then again, Judge Anderson actually discussed that language. That language is in the same paragraph where he finds my client guilty.
But I
Yes.
think, if you look at it, it says that counsel stated that we expressly consent to the second
We
amendment.
agree with that.
Yes.
Yes, ma'am. And I think it's a little formalistic, but I did in my brief mention that if he would have been convicted and sentenced, let's say, forget about the jury trial issue, if he would have been convicted and sentenced to 1 year, he would have come here and argued what? About the charging document not conveying jurisdiction over the 1-year offense. And I know that's not what was before y'all right now, but I have a hard time being able to come up with an argument that somebody in that situation would be able to make. Because on its face, it appears to allege a 1-year offense on the piece of paper. And I know it's very formalistic that it wasn't actually amended, but as the federal case law talks about, when you look at somebody's prior record for purposes of whether it was a prior conviction for a serious crime of serious felony drug crime or a crime of violence, we look at the charging document. And we wouldn't go back in and look at the transcript. And on the face of this charging document, and the only charging document in this case, it does appear to allege a 1-year offense.
So is your position that, I think his status conference was like in November of 23 or something like that?
Yes, ma'am.
And at that time, the government made the notice, but is notice of amendment, is your position that that would be insufficient?
Let me compare it to a civil case, because we talked about amended complaints, The litigants before me talked about amended complaints. If you move to amend your complaint to add whatever it may be, a party, a cause of action, et cetera, and or a defense or an affirmative defense or a counterclaim, and the other side agrees to it, if you never file it, there's never an amendment to it. And so I think that's very formalistically, but I do think that's a problem for the government
But
in this case.
my guess is they would probably say the amended penalty sheet was there. I get what you're saying, but I assume that would be.
I agree, and that is their
argument.
response, I believe, in their,
Okay.
in their brief. And I didn't lead with this issue because the question that was posed on the oral argument notice was my second question. So, but I do believe that that is still accurate, and it is not a constitutional question, it's a matter of indictment. And I know it's no longer, after Cotton, we don't deal with subject matter jurisdiction. That's not the same question it was before Cotton. But we still have this issue that the indictment has to allege the crime. And I'm not saying that it's a scrivener's error that we're dealing with. It was alleged as a B1 penalty. That's what listed the indictment. That's what he was initially arraigned for. And it does have the intimidate language.
So you're saying the indictment was not amended?
That's correct. It was agreed, it was allowed to be amended and consented to.
But Judge Anderson said to the contrary, and said he had 3 circuits that he was ruling consistent with.
Judge, he did try the case as if it had been amended. We will agree with that because, and I point out in my brief, he actually stops my client from examining one of the witnesses about whether or not he had done anything that was a threat or use of force against anyone, and there was an objection sustained, and Judge Anderson said that's not relevant, you're not charged with that. And we agree that
And he wrote in his opinion,
yes,
here, defendant faced a maximum term of 6 months.
that's correct, Your Honor. Nonetheless, the only indictment, there's no information, there's no other type of filing, there's no amended indictment, there's no superseding indictment, and for what it's worth, he was indicted. And if it was in fact a petty offense, he would not have to be indicted on it. And he was indicted because that
You
would.
can be indicted on.
That's correct, Judge.
The grand jury can charge somebody with a misdemeanor or a petty
Yes, sir.
offense with anything.
Yeah, absolutely, Your Honor. But they could not present a one-year offense through an information.
Well, the judge says he was presented with a 6-month offense in this, on page 3 of his opinion here.
And we just cannot, and I was not the
On his
trial
order. His order is called an order on defendant's right to a jury trial.
Yes, yes, sir, and I do
He
see
says-
that. There
He
is no
said the
question.
defendant faces a maximum term of 6 months.
And Judge, I understand it. It's tried that way.
Offenses carrying a prison sentence of 6 months or less are presumed to be petty. There you go.
Oh, Judge, we certainly understand that, and we agree that presumption of pettiness.
And he recognized, he said the Fourth Circuit Court of Appeals has not had an opportunity to address this issue. Other courts of appeals have.
Yeah, that's correct, Judge.
And he cited 3 of them, I think, 2nd, 7th, and 11th.
That's correct. That's correct, Judge. However, what we do have is a consistent treatment by the Supreme Court. Not one decision by the United States Supreme Court regarding an individual's right to a jury trial exceeds the petty offense statute. And in fact, the opinions especially, because 1937, we go to a statutory maximum methodology. We no longer look at the penalty imposed, we look at what you do face, because common law did not work with all the new offenses coming after the Industrial Revolution. And so then in 1948, they passed the first petty offense statute. It is statute 1 in the criminal code. And aside from the impact on the right to a jury trial, that statute has no other significance in 1948. Now we know petty offenses can be treated differently under Rule 59 charging documents, or you don't get a pre-sentence report with a guidelines calculation.
But hasn't the Supreme Court told us to place the maximum emphasis on the prison term that a person faces? That, you know, they've said it, 5 or 6 different ways to emphasize that what matters most for determining whether there's a petty offense that doesn't have a right to a jury trial is how much time a person faces in prison. Now, we might disagree with the Supreme Court that 6 months should be the line, but they've drawn the line at 6 months when it comes to a jury.
In the 6 months, we see the 6 months develop as it goes through. We have Sheff says 6 months is petty. We have Duncan applying it to the states, and that says 2 years is not petty. We have Ford in between. It's a contempt case. I won't address that, but it does talk about probation. Then we have Baldwin, and Baldwin comes in and says that 1 year is too much. Then, well, I'll skip Munez because the only jury trial issued constitutionally in Munez is a corporation. But when we get to Blanton, the case that comes up next, it talks in there about a fine and other things. And this is important because Soderno's the leading case on the FACE Act. There's no question about it. Posner's opinion is the leading one, and that's adopted by the other circuits. In fact, almost in full. They just cite Soderno. So in Unterberger, Ketchum, and Dugan, all of them cite Soderno. But what we do have in that is, and they never say it, the fine in Blanton falls within what at the time was 18 U.S.C. Section 1. So it's still with the statute. And as I mentioned earlier, not one U.S. Supreme Court case disregards that. Because, Judge Rushing, as you mentioned, the court says we look at statutory penalty. But before that, they said you look at the legislature's treatment of it. And that they should respect the legislature's treatment. And here's what we know the legislature does. They pass laws that apply to other laws. So whether you are eligible for good time credits, or whether you get a pre-sentence report, or whether you have a fine of a certain amount, those are not all written into one individual criminal statute. Those are all cross-referenced. On this, we have at least until 1987. By 1984, 18 U.S.C. Section 1 is then repealed, and it stays in effect for some period of time. 1987, they passed the subsequent 18 U.S.C. 19. But what we know is that every one of these cases is consistent with those two statutes, and the legislature
But that's not the
addresses those.
test that they've articulated, right? Now, you might be finding something that they haven't articulated, that it's consistent with something that they haven't said is the test, but when the Supreme Court's directed us that the legislative determination of seriousness is what we should be looking for.
Yes, ma'am.
They've pointed us, they've emphasized what matters most, that the best indicator of that is the prison time that someone faces. And then they say, unless the other penalties are so severe that they clearly reflect that despite, only facing 6 months in prison, Congress meant for this to be considered a serious offense. So what's your argument that, $10,000 is so severe that it shows us that? I don't think, the court hasn't pointed us just to the statute and said, well, if it's $1 more, that's so severe.
There's no goalpost on the other side as of right now from the U.S. Supreme Court. And that's what I mentioned. Every single case that has gone up there, Blanton was a $1,000 fine when it was $5,000, so it was under it. Nocatol is the one that talks about, well, Nocatol's 5 times what the court had in Blanton, still falls within the statute. And I appreciate your time. I think here, let me make this argument, and I'm going to come back and reply.
You'll save some time.
Yes, sir. Thank you.
Mr. Pearson?
May it please the court, Dwayne Pearson for the United States of America. Your Honors, in Apprendi, the Supreme Court set the standard that all elements for an offense must be charged in the charging document if those elements increase the penalty. The indictment in this case was clear from the beginning that the defendant was not facing the 1-year maximum penalty. In fact, if we go to the indictment itself, the face of the indictment, it shows that while it tracks the language of 248B, it goes on to specifically claim that the defendant did block the front doors, making it difficult for employees and patients to get around him and enter the clinic. It does not allege any intimidation. To go to your point, Judge Rushing.
But doesn't it, like the sentence before, alleges intimidation?
It does, but that's why there's a clarification sentence, because in tracking the statute can be violated either by intimidating or interfering with.
If he had blocked the doors with a firearm, wouldn't that have been intimidating?
It could be, yes.
But the indictment doesn't have to tell us all those details, and it doesn't tell us all those details.
No, it doesn't tell us all those details, but under Apprendi, in order for the government to go forward on the higher penalty, we would have to allege it in the indictment, and this indictment, or information in this case. And this doesn't say that.
So you're saying that this indictment, as originally written, would not have let you pursue a 1-year penalty?
No.
Why? Because of this extra sentence explaining that he blocked the doors?
Because we would have had to allege violence.
But you allege by physical obstruction, he did intentionally intimidate and interfere and attempt to intimidate. And then you would show me that the statute defines intimidate as to place a person in reasonable apprehension of bodily harm to him or herself or to another. How do you do that without at least a threat of violence? How do you place a person in reasonable apprehension of bodily harm?
Your Honor, it's the government's position that in this case, he was charged with interfering with. Although that...
But you realize the indictment also says intimidate.
I do, Your Honor.
And you didn't strike that part. Even you amended it to take out the 1 after the B, if we grant you that, but you never struck the intimidation.
That's correct, Your Honor.
So how did it not allege intimidation?
Your Honor, I believe the better practice would have been to strike it, and the government did not do that. It is our position that we were clear in going the extra step to outline specifically what we were alleging that the defendant did, that it would take it out of that. But Your Honor, your Honor's point is well taken. It would have been the better practice to strike those two terms from the indictment.
It's a strange situation, right? Because you would think in most cases when the government says, hey, we're only going to seek 6 months, don't worry, that a defendant would be like glad about that, right? Oh, it's not a year, it's 6 months, that's great. But here, he actually is wanting it to be a year because of the jury right. So I understand why the government might have thought everybody's going to be on board with this, but the face of the indictment is hard to get around in terms of the definition of intimidate.
Yes, Your Honor.
But that was presented to Judge Anderson, and he spelled it out on page 3 of his opinion.
Yes, Your Honor.
And he ruled specifically the defendant faces a maximum term of 6 months.
Yes, Your Honor, and that goes.
And was that correct? If someone has been accused in the indictment of intimidation under this statute, do they face a penalty of 6 months?
If all they were charged with is intimidation, and the statute, or excuse me, and the indictment follows the guidance in Apprendi and makes it, and alleges that, then I believe it could be, but I do not believe that's where we are in this case.
I'm sorry, I didn't follow. So if under the FACE Act, someone's indicted with intentionally intimidating, physically obstructed by intentionally intimidating, do they face 1 year or 6 months?
If they're,
Max.
I'm sorry?
Max.
If they are charged with intimidating based on the definition, yes, Your Honor, that could be a 1 year, that could be a 1 year charge.
But you're saying it wasn't here.
But it was not here.
And that was clear, or that was explained by the judge in his order.
Yes, Your Honor.
He calls it an order.
And
It's a four-page
So why
opinion.
wasn't it here? What-
Order on defendant's right to a jury trial, and he was the trial judge.
Yes, sir.
Can the trial judge amend the indictment?
Not typically, however, the government can amend an information on a petty offense.
Right.
And in this case, Your Honor, as
This is not information, you said.
Yeah, they could on an information, they could. We could. And it is a bit of an odd circumstance because since it is a 6 month offense, the government can present it to a grand jury, or we can simply
You could
present it as
present it to the grand
an-
jury, the U.S. attorney could file an information. But you said this is an indictment.
Yes, Your Honor.
But the judge, and it was tried by the judge, and the judge wrote, explained, and said specifically, defendant faces a maximum term of imprisonment for 6 months.
Yes, it was very clear on the record.
So he was, yeah.
And in fact, Your Honor,
Did Lewis address this? I thought the Supreme Court in Lewis faced a situation where the district court said, you know, I won't sentence you to more than 6 months, so don't worry about it, even though the statutory max was more. I think the court didn't have to reach that, but they were faced with a situation, well, would that be enough? Well, I guess what's your answer there? If Judge Anderson said, you know, no matter what the indictment says, I won't sentence you to more than 6 months, so does that mean no jury?
Your Honor, I do believe the Lewis case stands for what we are looking at is the emphasis on the maximum term. If the maximum term that a person could get is 6 months, then they would not be entitled to a jury trial.
But Judge Anderson didn't say, but if, whatever that says, but referring to the indictment, but he explains ahead of time, he says specifically, defendant faces a maximum term of 6 months, plus a fine.
Yes, Your Honor, and if I may, I would also like to point out that the defendant was never under the impression that he was looking at a 1 year penalty in this case. If we go back to the record during his initial appearance, when the court indicated that there was a 1 year penalty, the defendant himself made the correction and said, no, I believe that I'm only looking at 6 months because it was a nonviolent offense. And I believe that takes us to behavior that is incorporated in Rule of Criminal Procedure 7C2, which would require a defendant to show that he was misled and thereby prejudiced. The defendant in this case was never misled as to what he was facing. From the very beginning, he knew he was looking at a 6-month offense. I do understand the court's questioning about what an indictment could say, but in this particular case, the defendant only ever was looking at that 6-month penalty.
As a follow-up to Judge Rushing's question, earlier you stated that if the indictment, if the government was alleging intimidation or physical intimidation or harm, that you would have had to state more in the indictment? Can you explain that?
Yes, Your Honor. Apprendi stands for the proposition that the government is required to plead and prove anything that increases the maximum penalty in the indictment and then subsequently prove it to generally the jury. In this case, the government would have had to specifically prove violence in order for the 1-year penalty, would have to allege it and then prove it in order for that 1-year penalty to apply. And it is a bit odd the way the statute is set up in that B1 talks about the typical 1-year penalty, and then there's a paragraph below B1 that is not designated as 2 or paragraph C or anything like that. I believe the colloquial term is flush language of the statute is at the bottom, and it provides that penalty limiting instruction. That penalty limiting instruction.
Penalty limiting allegation.
Yes, Your Honor.
Description. And that's the point I'm trying to make you to. The judge, who was the judge and jury, he tried the case.
Yes, sir.
He said this indictment, under this indictment, the defendant faces a maximum term of imprisonment of 6 months. He wasn't the appeals court judge. He was the judge that had this case. He was going to
But the question here is
whether it was a jury or presented only to the judge. He says he faces 6 months based on this indictment.
And the question is, was that correct? And I'm interested in your answer to Judge Benjamin's question about what else would you have to have alleged in the indictment to have received a 1-year maximum to allege intimidation?
Yes, Your Honor. So the penalty limiting instruction actually talks about a case of nonviolence. So we would have to specifically say that it was not a nonviolent obstruction. We would have to allege violence in some way. And I believe in this case, the government went far enough in the indictment to say that what we're alleging was that he made it difficult to enter, and that is not an allegation of violence.
So you would have, so I guess under Holt, if you were to say because it would be substantial that you were going to add the violence piece, you would have, at that point, you would have had to take it back before the grand jury.
Yes, Your Honor. We would have to say something along the lines of, to take Judge Rushing's example, and did brandish a firearm in order to intimidate, or and did use physical force against another individual. We would have to specifically allege it. And
what if the indictment didn't have the clause coming after, in that the defendant did block the front doors, making it difficult? What if you just didn't have that part? And so it alleged the defendant, by physical obstruction, did intentionally intimidate and interfere, or attempt to intimidate and interfere with employees and patients, blah, blah. But then you didn't have how he did it.
Well, I think in that case, that's really where Apprendi applies, because at that point, it would be unclear as to what the government was saying. It would be unclear as to whether or not we were saying that he intimidated or whether or not he interfered with, and based on...
But would that be an Apprendi problem, or would that just be like he could ask for you to specify what he did? That's not a problem that you're not putting in the elements that would subject him to a higher penalty. You've put in the element. You've put in that he intimidated, which involves violence.
Your Honor, but because the statute can be violated either way, with the intimidation or the interference. In order for us to seek the higher penalty under Apprendi, we would have to make it clear.
Well, no,
Otherwise-
you've put him on notice that you might be subject to the higher penalty or the lower penalty.
Well, if it's vague,
right?
if
It
it's
can do
vague
both,
and you
can
got
it not?
those alternatives, you just give them the judge will order you to give them a bill of particulars.
Right.
There's a rule on bill of particulars,
Yes, Your Honor, there
and
is,
the bill of particulars can explain that.
yes, Your
What
Honor,
the-
there,
What the facts are that justifies this charge. And
yes, Your Honor, there,
And what you're saying, I think, you all, and this is the way good prosecutors do it, they put the particulars in the indictment.
Yes,
They
Your
don't
Honor.
have to give a bill of particulars.
yes, Your Honor. In this particular case, or I'm sorry, to go back to Judge Rushing's point, I believe while there could be a bill of particulars, I do believe there is an Apprendi problem if the statute is unclear and one of the ways to violate the statute increases the penalty, because at that point, a defendant is looking at something that now he's got to show up at trial and prove. Meaning, in a case like this, the defendant would have to show up in trial and prove that his violation was the nonviolent, and that is a burden shifting problem. Because now, instead of the government having to allege all of the elements that increase the penalty, we would then be putting a burden on the defendant to come in and prove that his violation was solely a nonviolent issue. To put a fine point on that, it is the position of the government also that, again, this really falls into things contemplated under Rule 7C2. As the defendant cannot show that he was misled, as he was very clear and knowledgeable on what the penalty for the violation was from the very beginning, he can't show that the error would be grounds to dismiss the indictment or reverse his conviction in this case. To address whether the FACE Act creates an inherent right to a jury trial, Your Honors, the defendant claims that there is a circuit split. However, a closer inspection shows that his reliance on the district court case of Lucerno was faulty because that court did not perform the required analysis. If we go all the way back to Muniz in 1975, the Supreme Court even there held that there is no talismanic significance to the statutory definition, and it then rejected the view that an increase in the fine would necessitate a jury trial in that case. If we take that next to Blanton in '89, that court served as the framework for the presumption that a 6-month offense is presumed to be petty, and that you would get a jury trial only if the additional penalties were so severe as to warrant one. We then move to Nagicol in '93, which emphasized that only in rare circumstances would something other than incarceration shift the crime from petty to serious. And then we run into Lucero in '95, quoting McAllister. That McAllister case that Lucero is based on was decided before the Supreme Court decided Blanton, and it did not perform the required analysis that came out of Lewis, that came out of Nagicol, and I would also point out that even in that McAllister case, it says specifically that until the Supreme Court speaks further, the definition of petty will be determinative. Well, the Lewis and Blanton cases are the Supreme Court speaking further, saying that that what we need to do is look at the maximum penalty, and that should be the guiding force that we have. As noted in '96, in the '96 Sedurna case, an increase in fine, a modest increase in fine, is what we saw in that case, and it's nearly identical to the increase noted in Blanton. In fact, the Blanton case had the Nagicol case had a 5-time increase in fine from $1,000 to $5,000. if we're just talking real dollars, that's only $4,000 back in 1993. The government would point out that the increase in fine in this case from $5,000 to $10,000 is likely less in real dollars in 2025 than the $4,000 increase was back.
You're saying we ought to be able to take inflation into account?
I'm just pointing out in terms of making.
I never heard that.
Your Honor, I'm just saying in terms of taking into account whether or not something is serious, it is appropriate to take into account real dollars. If
That's what you're saying, but we gotta consider, we can't look at the face of the statute about the penalty, we have to look at inflation.
All of it, Your Honor, in making this determination as to whether or not the increase would warrant treatment as serious. Accordingly, after the Lucero decision, the Second Circuit, the Seventh Circuit, and the 11th have specifically held that first-time, nonviolent, FACE Act offenses are not serious and do not require jury trials. This court should join them. Contrary to his argument, the facts of this case show that the defendant was not charged with a serious offense, and he cannot overcome this presumption that the additional $5,000 penalty is so onerous that it would make his first-time nonviolent conviction serious. The government would respectfully request the judgment of the district court to be affirmed. Thank you.
Thank you very much, Mr. Pearson. Mr. Brown.
Just briefly in reply, the McAllister case says that until the Supreme Court tells us otherwise, they have followed the petty offense statute.
How do you get
Yes.
past Judge Anderson's ruling
Yes, sir.
before the trial
Yes, sir.
that the defendant faces a maximum term of imprisonment of 6 months?
Judge, I
And
don't
put it
dispute
in
that.
writing and,
Yes, sir.
and provided it to you, and says, therefore, the court finds that the defendant is not entitled to a jury trial.
Yes, sir.
Thus, this matter will proceed to a bench trial on February the 6th. That's a month after he wrote this order.
Yes, sir. We don't allege there's any
But
surprise.
he said, this is the judge.
Yes, sir.
Who's going to try the case.
Yes, sir.
The defendant faces a maximum term of imprisonment of 6 months. In this case,
Yes, sir.
with the particularization of what's alleged in the indictment.
Yes, sir.
You got the language of the statute first in the indictment.
Yes, sir.
Then you got the specification of what the facts are that they're going to, that they allege they're going to prove. And the judge took that into account and says the maximum term under this statute is 6 months.
Yes, sir. I don't dispute that those are his words. And Judge, the reason I briefed issue 1 is that on its face, the indictment alleges an offense that carries 1 year. And it was never amended. There is one charging document.
Well, you have to read the whole indictment.
Yes, sir. That whole indictment was
And
never
the judge
changed.
did. He read the second part also.
Yes,
And
sir.
that, and under the facts alleged, as Judge Anderson said, it's 6 months.
And Judge, and the only thing I can tell you
He
is I think.
didn't, Judge Anderson didn't come over on the pickle boat. He's been
Oh,
around.
no, I have great respect for Judge Anderson. I think he's a very reasoned and moderate judge and around for a long time and very well respected by everyone. And the only thing I can
That
say is to
sounds-
the indictment is that, yes, ma'am.
That sounds kind of like a harmlessness argument, I guess, that like, well, the judge said he was only, this was an offense for only 6 months, so like, how were you injured? So how was Mr. Lefamine injured if that was the case?
How was he injured by not getting his jury trial?
Right.
Because the indictment itself formalistically alleged a 1-year offense.
And you think he was entitled to a jury?
Because it was not actually amended. And I understand for every purpose except the document. And that is why I come back to those other cases that look back on prior convictions for like armed career criminal purposes. They look at the charging document. And in this case, this charging document would appear to allege that my client intimidated someone subject up to 1 year. On the face words of that. And they would never go back and look at Judge Anderson's order or the fact anyone else consented. That there's no place under the Shepherd, I believe, is some of those cases that talks about how to look at prior convictions. And I'm just saying, when you look at it in retrospect, He has this one indictment. It's not like Judge Anderson found as a lesser included and acquitted him of the greater, although that in some respects is what the order on the jury trial says.
But you would agree that there was, that council acknowledged the amendment, there was no objection.
Yes, ma'am.
And-
All of that.
And I think the government says that at his arraignment, even Mr. and I want for Lafamine acknowledged that it was 6 months.
Yes, ma'am.
And
We agree with
the
all of that.
purpose of the indictment is to put defendants on notice of the charges.
It is, but there's still a requirement that it allege the facts that he's charged with and allege the statute. And I know you can have a scrivener's error that doesn't change it, but in this case, it would be hard pressed for me to tell a client that came in with that indictment, he did not face 1 year. They would be very hard pressed to say that on the face of the indictment.
And what about their argument, the government's argument under 7C2, that this was just a scrivener's error, and everything else that happened, I guess, in the case.
Well, I think the indictment language alleges a 1 year. And Judge Rushing has pointed that out. And I don't think any other facts are necessary to make an intimidation. I think intimidation would be the subjective view of the
No, I
people who are
mean,
being obstructed.
they're saying under Rule 7C2, that there's no, the alterations that they made before, I guess the court did not prejudice.
Because I don't believe they made the alterations. That's my point. Is I think if they would have amended it, it would not have had a problem under 7C. They just did not do it.
But
It's like the amended complaint.
Well, I think the government's point is 7C2 says an error in a citation or an omission in a citation is not grounds for a reversal. So
Yes, ma'am.
if we're talking about just the citation
And I'm
point,
not.
you have a hard.
Right, and I'm not. I believe it's both the language, intimidate clearly alleges some type of threat to harm someone, because it says harm. The word violent actually never appears anywhere except exclusively nonviolent in the penalty section. The word violent or violence appears nowhere in it.
One last question. So
Yes.
under Apprendi, the government stated that they would have to, if there was violence, I guess if you use Judge Rushing's example, if he was standing there with a gun or something, then do you agree with the government's assertion that the indictment would have required more?
I do not. That's what I was saying to begin with. If a client brought me that indictment, I believe it charges a 1-year offense. Intimidate, and it doesn't use the word violence. I don't think they have to say violence.
Well, you could advise your client that the statute permissibly could charge a 1-year offense.
Yes, sir.
But you got a trial judge whose rules in this particular case,
Yes, sir.
as to this indictment,
Yes, sir.
it charges 6 months.
Yes, sir. And we
And
agree.
that was what the ruling was a month before the trial.
We
And
agree
he
with that.
conducted the trial, and he didn't sentence him to more than 6 months.
He did not. He did find that he intimidated him.
So the judge understood it was only 6 months, and he so ruled and
Yes, sir.
explicitly spelled it out on this record.
Yes, sir. Absolutely. And if I may, 1 second, the Lewis opinion actually is still consistent. Lewis defendant only faced 6 months per count. But they could have been run consecutively, and that was the issue. And the court there treated it as one offense. So they still were all consistent with petty crimes.
Mr. Brown, you're court
Thank you.
appointed, and
Yes, sir.
we really appreciate your service
Thank you for having me here,
to
and
the
I always
court,
enjoy
to the
coming
court
forward.
system.
Yes, sir.
Doing that. Thank you very much.
Thank you, Judge.
And we'll adjourn court for the week, for the sine and die, and we'll come down and greet counsel, and we're retired of our conference, and thank all of you for being here, and all safe travels.
This honorable court stands adjourned, signing